Okay, it is 8:30. We'll go ahead and get started. And we just hit the 100 mark. Welcome, everyone. So today we are going to be discussing the Fed Osha vaccine mandate and the emergency temporary standard and how that's recently been blocked. And we're going to answer that question, now what? Today's presenters have a variety of expertise. We have HR, claims advocacy, risk management, and then myself. My name is Cassandra Fullerton, and I am an account manager in the customer success department here at ESM. I joined last year, and this is my first webinar with ESM, so I'm very excited. It's great to be here with you all, and I help with any questions on safety programs and on our Insight portal.
Yay, Cassandra, we're so glad you're here.
Thank you. All right, we can go to the next slide. So a little bit of housekeeping. Please note that the information we'll be talking about today is going to be California-centric. Also, we will be discussing safety and OSHA compliance, and we'll be discussing a framework for COVID risk management. And last but not least, again, please note, if you do have a question, we will follow up with you after. We're not going to be taking questions while the webinar is live because we have a lot of information for you. So please use that Q&A button because we can save those and we can answer it later. Please don't put your questions in the chat because we can't save those. Next slide. All right, so for today's topics, our first topic is going to be, of course, this Fed Osha ETS update and the Supreme Court decision. And then we'll also be discussing the California ETS updates, which happened on January 14th. And then we'll take that information and talk about how to develop your 2022 risk management plan and how to leverage technology to make that easier. And finally, utilizing those risk management results to obtain credits on your work comp premiums. So without further ado, we'll introduce Anthony to take us through the See's Candy COVID case.
Great, thank you, Cassandra. Welcome, everybody. Great to see so many familiar names, and in my mind, I can see all those familiar faces. So hopefully one day soon, we'll all be able to get back together again and maybe raise a glass that this thing is finally done. But here we are, year 3. And before we get started, I wanted to talk about briefly this See's Candy COVID-19 case. I've been sharing this with a lot of different individuals. Jennifer and I, you might have just heard us talking about it just really briefly before the webinar. But nonetheless, this civil case is really a little scary. And I think it will help kind of set the tone for the webinar. It feels like we got a little bit of reprieve from this short-term stay in this new Fed Osha ETS that was blocked. But there are still several other areas of concerns for potential financial exposures and penalties, including civil lawsuits, and also your workers' compensation coverage B in the policy. And I don't know if that's ever been utilized that I know of, but nonetheless, here's what happened. See's Candy, they had an employee contract COVID at work. They took it home, gave it to her husband, who subsequently died. So the employee filed a wrongful death claim, and over time, the appeals court said that they agreed. Now, that really set the precedent now that if we have COVID cases, we take them home to our families, there is the potential for not only the civil penalty, but also this can be considered under this coverage B of your workers' compensation policy, which basically means that now that my family got sick because I got sick at work, workers' compensation could extend that coverage to the family. And given the current climate that we're in, that I'm sure everybody has family and friends that are dealing with this incredible surge, that's a little bit scary. So I'm not going to go into the details of this. I've shared this as a case reference here. You can see at the bottom. In fact, Cassandra, you already put the link to the slides in the chat. So make sure you go grab those and then review this with your team. It's a short read, but nonetheless, what the takeaway is and what we've been preaching, I think, since we started this company 15 years ago, is that we need to document as much as possible. Document your compliance policies, your employee engagements, communications, your trainings. More documentation you have, the better you can defend yourself in any potential type of suit, such as this one. So take this home, take this back to your safety committee, review it with them, discuss any gaps in your documentation efforts. If you want to dive into this a little bit more, I'm sure Jennifer is well versed in this. We've got some experience in it, so we can gladly kind of talk you through some of those challenges. I don't want to take a
And
Go ahead,
Anthony,
Jennifer.
you pointed out that, document everything. And it's so important. And a lot of what we're reading right now is considered guidance, but you want to follow the guidance, because if you don't, and something like this happens, it's going to be saying, why didn't you follow the guidance? So I know there's all different kind of guidance, and we're going to get into that further down the webinar, but that's yet another reason to follow guidance when it's just phrased that way, and to document everything you're doing, whether it's in your COVID prevention plan or elsewhere because of cases like this. So good way to start the webinar.
Yes, and that's a great point. Follow the regs to the best you can. We know that the goalposts are constantly being moved, but if you're complying with the regs to the best you can, you're making a good faith effort, you're in a much better position than doing nothing. So let's talk about the next bill, Senate Bill 606. And we mentioned this in our prior webinar, so I don't want to go into details. Again, we put the reference here for you, but essentially there's two new violation categories, egregious and enterprise-wide. You can see the details of egregious on the left. What does that mean? It basically means this new law is requiring that each time an employee is exposed to a violation, that is considered to be a separate violation for purposes of issuing fines and penalties. So what does that mean? It means that employers need to be extremely careful during this pandemic. Multiple outbreaks, hospitalizations, even multiple fatalities, coupled with the lack of implementation or enforcement of your safety policies, that can lead to potential Cal OSHA penalties per employee. And then on the enterprise-wide side, it's really important to give special consideration to your written programs that span across multiple sites. Things like your COVID-19 prevention plan, your respiratory protection plan, your emergency action plans, heat illness, your trainings. So again, it's really important that you take this information back to your safety committee and maybe audit your policies, especially those that span across multiple sites. Make sure you have your safety committee up to speed on what these new regulations are. And of course, if you have any questions, feel free to reach out to us. So I hate to set the fear tone in this webinar, but Abe, let's see if we can dial it back with some good news about the ETS stay again.
Well, I don't know if I have good news for you, Anthony, but I can certainly give you an update on the OSHA ETS and vaccine mandate. One of the things that we went over in one of our prior webinars was the federal side of it, but I just wanted to do a quick recap of what did happen with that. Obviously, part of 2022 is going to be managing COVID exposures. We have record cases, as you've probably seen, driven by the Omicron variant. We all know that we still have a duty to maintain a safe work environment, regardless of what the Supreme Court says, and we still have to comply with California's ETS. So what happened with the Fed OSHA? Well, if you're not familiar with the differences, so the Fed OSHA ETS, basically the overview and background is that they state that many unvaccinated employees in the US pose a grave danger to exposure in the workplace. And because of that grave danger, there was a need for protection, and the way that they were going to protect was the most effective and efficient workplace control available, which is the vaccination. And the purpose was really to establish a minimum vaccination, verification, face covering, and testing requirements. And another purpose that they state was to prevent state and local laws from limiting the employer to require vaccination. So we've already seen that in a couple different jurisdictions like Texas and Florida, for example. So what happened with this Fed OSHA ETS, or this emergency temporary standard? Let's move forward to the legal status. So there's a lot of back and forth. You probably saw some of the appeals court, different stays and removals of stays. Well, the initial block was on November 12th for the OSHA mandate, the vaccination mandate. And the 3-judge panel from the 6th Circuit lifted that block on December 17th, basically reinstating the ETS. If you've been following along, you saw that the Supreme Court heard oral arguments on the 7th of this month and then issued their opinion on the 13th, saying that they're going to put a hold on the broad mandate for large employers pending further review from the 6th Circuit Court of Appeals. Basically what they said was that it was too broad to implement through the emergency authority that OSHA is granted. So that doesn't necessarily mean that we won't have a mandate in some form. We actually saw the CMS mandate go through for healthcare workers. It's apparently specific enough to go ahead and go through with certain types of mandates and certain types of industries, and it doesn't limit the ability for employers to go ahead and require employees be vaccinated, or from states from adopting certain regulations revolving around a vaccine mandate. And of course, to do the opposite, like I mentioned, Florida and Texas are examples. So let's talk about the Fed Osha versus state plans, just to kind of dig into that a little bit more. So the federal government can largely enforce safety rules against private employers in 29 states, plus the District of Columbia and some other American territories. And the remaining 21 states have approved state plans where the state agency enforces safety regulations in that jurisdiction. So that is California. So California, we have had an emergency temporary standard for quite some time. So this is nothing new. If you're concerned with, what to do, many of you have already been complying in large part with California's emergency temporary standard. And the federal guidance basically has to be at least, the state plan has to be at least as effective as the federal guidance. So Cal OSHA, that was in effect. The ETS has been in effect since November 30th, and then it was extended in December, and we just got some additional updates on the 14th of this month. So let's do a little recap of what's in the emergency temporary standard, since it's been a while since we've kind of rehashed this, but nothing's changed here. And it's not limited to this, but these are the main elements of compliance with the emergency temporary standard. So you want to have a written policy for COVID-19. You are going to be providing information and training to your employees, as you all have been. We're notifying the local health department of outbreaks, and I'll go over that a little bit more. Notification to employees of exposures and close contacts. Again, nothing new. We've been doing that. Even before the emergency temporary standard in California, with the 685 notices. Offer testing to potential exposures. We're investigating cases and outbreaks as well. And isolation, exclusion pay, obviously that is ever changing. So Jennifer, I'm glad you're going over that. Housing and transportation, there's basic prevention. So if you're an employer that provides those, I would make sure to take a look at those as well. So the recent changes. These are the changes that were implemented on January 14th. They changed some of the definitions of COVID-19 test, face coverings, fully vaccinated. That you have to go ahead and make available COVID-19 testing, which is difficult because, as you may have heard, a lot of the testing is hard to find. There's updated timeframes for return to work. So we'll be talking about the isolation and quarantine, masking and physical distancing requirement for fully vaccinated, and outbreak testing requirements. You must make testing available on a weekly basis if you have an outbreak. And remember, there's a difference in California. There's an outbreak and then there's a major outbreak. Outbreak of 3 or more cases within a 2-week period. But if you have 20 or more cases within a 30-day period, that is a major outbreak. And there are some additional requirements that you have to comply with. And I would just cross that bridge if you come to it. There's not a lot more requirements, but just put it on note that you need to do some additional, comply with some additional requirements if there's a major outbreak.
Hey, Abe, real quick on the outbreak, the 3 or more is for the local health department, right? And then is it still true that workers' compensation is 4?
Right. So there's a totally different definition. Just to make it confusing, when they implemented the 1159 framework, basically they made it so that it's 4 within a 2-week period, but you don't have to really know that. I would keep 3 in your mind, because the carrier is the one that determines whether or not there's an outbreak for workers' comp purposes. So as you're alerting the carrier of additional cases that come in, they're going to be keeping an eye on when there is an outbreak for work comp purposes. So I would just keep in mind 3, because that's going to trigger the employer to take action, such as notifying the local health department.
Yeah, I think that's the scary part, to think that the carrier could say, you've had an outbreak and we're going to deem these compensable. And therefore, kind of going back to that See's Candy case. Now, if those COVID cases are deemed work related by the carrier, that civil case comes into play, or the coverage B comes into play if those employees take it home. So Lynn, we see your question. We're going to try to answer that here a little bit further. But nonetheless, I wanted to make that bridge between outbreaks, work-related, and the potential exposure to coverage B, or that civil case that we saw with Seeds.
Yeah, absolutely. And I am seeing a lot of denials. I mean, even when you do have an outbreak, what the carrier does is presume those to be compensable. So they're not going to be automatically accepted. We're just going to file the claims if anyone alleges that they have a work-related exposure, and let the carrier do the investigation. But I am seeing a lot of denials, and luckily, I guess we could say, there's not a lot of exposure on most of the COVID cases. Obviously, it can go the other way with deaths or people that are hospitalized. And I ran through this a little bit before, but the latest Cal OSHA ETS updates effective January 14th, going through April 14th of this year. It's supposed to be a temporary standard. So we'll see how far that gets extended. OSHA obviously can issue citations. They have always been able to issue citations, but they'll be taking a look at those revised provisions. And I already went through the OSHA ETS has been effective since November 30th. So a lot of this, none of it is new, but just the ones that we'll be going through today are we're gonna highlight some of the new elements of it. So vaccine compliance, as Jennifer alluded to, there are a variety of local health department rules that you want to follow, and it's not limited to just the vaccine. I would specifically take a look with regard to isolation and quarantine, which we'll talk about in a minute here. But mandates may still be implemented at the employer's option. They may be implemented through other means rather than the federal OSHA route. Obviously, there's some exceptions, such as the religious and medical exemption. Just will depend on the specific employee. And there are also, as I mentioned a few times, different states that prevent or block an employer from doing so. And there's still going to be litigation on all of this, rest assured. Vaccination documentation and record keeping requirement, there's really not a whole lot changed there. We're actually going to talk about the vaccine policy next. So we're going to be verifying the vaccination status of each employee. If an employer isn't able to do that or doesn't wish to do that, you have to treat all your employees as unvaccinated. I would say that it's pretty easy in California. I know Anthony and I have both gone through this My Vaccine report. At the bottom there's a little link. It's actually myvaccinerecord.cdph, and you really just enter your name and your birth date, and it'll pop up a QR code and show the dates you were vaccinated. It really doesn't take much more than that. So there are other acceptable means of getting the vaccine records. Obviously, you can use those cards still, records from immunization forms from a healthcare provider, copy of vaccination records, other medical records, and you have to treat all of this as a medical record. So there's legal requirements around that. And if you are deciding to require people to be vaccinated, just keep in mind that there is paid time and travel time for the vaccination series doses. All right, jumping ahead to testing. So in the ETS, we know that we have to offer testing at no cost to employees during paid time to symptomatic unvaccinated employees, regardless of whether we know that there's an exposure. Nothing's changed on that front. All employees who've had close contact with a COVID-19 case except for recently recovered employees. And remember, recently recovered is that 90-day window after a positive test. All employees except for recently recovered employees, regardless of vaccination status in an outbreak or a major outbreak, we just define those. And when following CDPH isolation and quarantine guidance, which we'll be talking about in an upcoming slide, but if somebody is isolating or quarantining and they're coming back, there are some requirements to continue wearing a mask. Which is a good transition. So basically, face coverings are required indoors and in vehicles for unvaccinated employees. That's per the ETS. However, the CDPH currently requires face coverings in all indoor workplaces and certain indoor public settings, regardless of vaccination status. And that's probably due to the Omicron surge right now. But there are exceptions when you're alone in a room or alone in a vehicle, eating or drinking. If there's some type of accommodation required, or when job duties make face coverings hazardous, effectively. One other thing that they did change was that if, regardless of vaccination status, if you're if you're traveling in employer-provided transportation, you have to mask up, even if you're vaccinated. Okay, the fun grid of information for isolation and quarantine. There seems to be a little bit of confusion on what the differences are, but basically if you're testing positive or you're sick, you're going to be isolating. If you're just exposed or you have a close contact with somebody that has COVID-19, you're going to quarantine. Those employees who are fully vaccinated and boosted, so you'll see that the CDPH, CDC, they introduced this idea of being boosted to the isolation and quarantine framework. You're going to get tested after 5 days. If you're negative, you can go ahead and come back to work, but you're still going to wear your mask for the 10 days. But you actually don't need to quarantine if you're fully vaccinated and boosted. The difference is if you're not boosted but eligible to be boosted, you're treated as basically unvaccinated and you must quarantine. So the same idea, you're going to get tested after the 5 days after a close contact, and you're going to continue monitoring and making sure you don't have any symptoms, and you can come back as long as you're asymptomatic and you have a negative test. Employees who test positive, then you're going to revert over to the isolation framework. And one thing I'll say before I go any further into this is that the CDPH went ahead and released some really nice guidance on this. You can see the two references here for isolation and quarantine. So if this is a little confusing, it might take a little time to kind of digest. I would take a look at their resources. They're about 1 page each. And so if you have anybody that needs to potentially isolate or quarantine, it's a nice guide just to take a look. But for people that are going to isolate, we're going to do it for at least 5 days. They can return to the workplace after 5 days if symptoms are not present. So they have to be asymptomatic and they have to test negative. And we're going to continue to wear a mask through your day 10.
Hey, Abe, can I comment really quickly? Because I saw some questions come in because this is such a hot topic.
Yes.
Jennifer here. Somebody had a comment about, what do we do if we can't get tested? There's such a lack of tests. What do we do in that situation? And I mean, the CDP chart and guidance that Osha has also adopted has kind of an option for that. They say if a worker cannot get tested, basically you default to the old rule of they have to quarantine for 10 days. So I think the guidance is anticipating that issue. The tests might not always be available. So if a worker cannot be tested, they follow the 10-day rule and they can return after 10 days of quarantine. Also, there was a question about, it seems like it's risky to have an asymptomatic exposed employee return after 5 days. Well, a lot of this guidance, there's people saying that it's, more economic, that they want people back working. And if you're concerned about, returning somebody who's asymptomatic after 5 days, if they test negative, you can always be more restrictive in what you do. So you could have a policy that requires, employees to wait 10 days to quarantine. So you can always do more than what the guidance requires. So I just wanted to point that out.
No,
Jennifer,
that's a great point. And let me just jump in real quick, Anthony. I want to mention something because we talked about it. I think it was before the webinar. So just so that everybody knows, it's important to also check the local guidance for these types of restrictions, because like Santa Clara County, for example, there are certain examples where they might require to be more restrictive. So it's important to check those as well.
And Jennifer, while we're talking about testing, I know this question has come up quite a bit. Does an employer have to witness the employee take the test, or telehealth, or other options?
That is an excellent question. Well, effective January 14th, which was last Friday, the ETS second adoption does say that at-home self-tests are acceptable. However, they can't be both self-administered and self-reported. So in order to take a at-home test as an employer, it either needs to be in a way proctored and viewed by the employer or a telehealth provider. So that means, and I've heard, and there's nothing prohibiting it, that you could potentially do this via FaceTime, via Zoom, and do that remotely. But if you have a large workforce, that is going to be a huge administrative burden. So yes, effective January 14th, at-home tests are acceptable, but they have to be proctored either by the employer or by a telehealth provider. Does that answer your question?
It does. I'm just going to let that linger in the air for a little bit. No pun intended, I guess. But yes, we're getting a lot of questions regarding testing, and you have to require a negative test to come back to work. I think Abe mentioned you can be more restrictive. Again, these are minimum standards that we're talking about from an OSHA perspective. So if you want to be more restrictive, and again, check your local health department, because there might be more restrictions like the Santa Clara County. And I know there's a lot of questions coming through here. If you are going to put a question, make sure you put it in the Q&A box, because if we don't get to it, we can download those Q&A questions, and then we can put together some FAQs and follow up after the webinar as well.
And I'm seeing a lot of questions too about whether a negative test is required. Not necessarily. If an employee wants to return earlier at the 5 days, a negative test is required. If they can't get tested or are refusing to test, they can wait the full 10 days. So if you write out the full quarantine or isolation period, then no, you can't require a negative test. People can have it in their system for quite a long time. So you can't, and if you want to return early, you can require a negative test. But if you write out the full quarantine or isolation, you're not going to require a negative test at that point. All right, looks like we're moving on.
Great discussion. Well, let me just finish up this slide quick, and then Jennifer, if you feel free to add anything to this as well. I kind of just threw this together as some tasks or things to think about moving forward. What do we do next? I mean, really continue complying with the OSHA ETS. I mean, a lot of you have already been doing this. Keep the January 14th updates in mind. We're going to say it again, check with the local health department for guidance and additional requirements. You're going to review your COVID-19 prevention plan to ensure compliance. Just continue training your workforce and ensure compliance of the notifications as well. Something that sometimes is missed. We have to notify our employees, the local health department, and the claims administrator of cases that do come in. And with that, I think if you have anything else, Jennifer, you can go ahead and add that. Otherwise, we'll move on to exclusion pay and benefits.
Yeah, and I mean, the only thing I would really add to that about what you can do now, and a lot of you have probably already done this, but as you can see by what we're talking about, there's a big distinction in how the rules are going to apply depending on vaccination status. So if you haven't already done so, you're going to want to collect that information. And now information on booster status has become relevant here in California. So a lot of employers are concerned that they don't have the right to collect that. You certainly do. And I would, if you haven't already started doing so, I would collect information on your employees because it is going to be relevant, because different workplace rules are going to apply depending on vaccination status. So that's one other thing I'd start doing if you haven't already done so. And now I'm going to talk about kind of, if I had to survey all the client questions we've gotten over the last several weeks, I would say this is the most often asked question is, we have all these employees out. What benefits or pay are they entitled to? And that's an excellent, excellent question. Cal OSHA's emergency temporary standard that we've been talking about requires something that we call exclusion pay under certain circumstances. It applies where an employee is required to be excluded from work because of a workplace COVID-19 exposure. Okay, so I want you to keep in mind that it isn't applying to COVID-19 cases. You don't have to pay exclusion pay to COVID-19 cases. They have other ways to receive wage replacement and compensation through either workers' compensation or state disability insurance. So it needs to be an exposure, and it needs to be a workplace exposure. So what does that mean, exclusion pay? Well, the regulations define it that employers must maintain the employee's earnings, wages, seniority, and all other rights and benefits of employment. So basically that means employers are on the hook to maintain the employee's earnings during the quarantine period. So this obligation will continue depending on how long they're out. Could be 5 days, could be 10 days. It does not apply, obviously, where an employee has COVID and is receiving temporary disability payments or SDI. It also does not apply where the employer is able to demonstrate that the close contact is not work-related. Okay, so if you have evidence and have done an investigation that there is no known workplace exposure and this employee's child has COVID or their significant other that they live with has COVID, well, then you would not be required to pay what we call exclusion pay. And this is really pay that's coming from the employer's own pocket. You cannot require employees to use paid sick leave. If you have a paid sick leave policy that meets the minimum standards of the Healthy Families, Healthy Workplaces Act, you can't require that they use that. If you have two separate sick leave policies, such as one that meets the minimum standards of the Healthy Workplaces, Healthy Families Act, and then you also provide a separate bank of what we call supplemental paid sick leave above and beyond that, you have more control over that, and you can require they use it. But if it's sick leave that you're using to comply with the labor code and the Healthy Workplaces, Healthy Families Act, you cannot require employees to use that type of paid sick leave to satisfy this obligation. So basically, if you take anything away from this slide, it does not apply to those who have COVID and are sick. They get SDI, they can apply for workers' compensation. It really applies to those employees who have been exposed at work and through no fault of their own cannot work, but have to be excluded. Okay, so there's a big distinction between COVID-19 cases and COVID-19 exposures. People used to recall that we used to have COVID-19 supplemental paid sick leave here in California. This was under SB 95 that required employees to provide supplemental COVID paid sick leave to employees who had exposures or were out sick with COVID. There were also federal tax credits under the American Rescue Plan Act that employees could potentially take advantage of. Both of those expired on November 30th, 2021. So there is no supplemental paid sick leave anymore, although we're hearing rumblings that that might be something that the legislature is contemplating given this big surge. But for now, if somebody is out because of COVID-19, they are actually sick with it, their wage replacement either comes through workers' compensation or SDI. If an employee is excluded, they may, under certain circumstances, be eligible for what we call exclusion pay under the Cal OSHA ETS. So I hope that answers some questions you might have had about how employees are getting paid during this time.
Thank you, Jennifer. That was amazing. And if any of you have any questions, please reach out to Jennifer and the Silvers HR team. They're a fantastic resource. As you can tell, Jennifer is well versed in this. They have great resources. They've been a great partner for us. So we're just really thankful for you to be here, Jennifer. And we're about to move forward past the COVID portion, but I wanted to just run through some of the questions because we're a little ahead of time. And I'm seeing just a couple of questions just with regards to what if we can't do this because tests aren't available, or how do we ensure that we're complying with the regs? And I think Abe mentioned very early on, there's an OSHA general duty clause that requires employers to maintain a safe and healthy work site. So make a good faith effort. Document what you can. If you can't get access to tests, there are nuances within the regulation that allows you to say, well, okay, well, if you can't come back, if you can't get tested, but you're symptomatic or asymptomatic, if you're asymptomatic, you can return to work. But just make sure you document those efforts because you are complying with the regs. And if you have any questions with that, I know we've got probably, I think we have 30 plus questions here in the chat. I think we've tried to answer some of those, but if we're not getting to those, again, make sure you put your question in chat if you, in the Q&A box, I'm sorry. If you put your question in chat, put it in the Q&A so we can download those later. And then Jennifer and Abe and I and our team will review those and then we'll be able to get some answers out to everybody. The other question was, yes, we're recording this, so we will be distributing this as well. We've already posted the slides. If you haven't seen those, just roll up in the chat and you'll see them there. Abe and Jennifer, before we move on, did you see any other questions that you wanted to address in the chat? We're just a little bit ahead of time.
Yeah, I see a few that I could maybe tackle. Specific to exclusion pay. Somebody asked, when is the start date for exclusion pay? I mean, it starts the first day that you're required to send them home to quarantine because they have been, you've done your contract tracing and they have been disclosed as a potential close contact who has to be excluded. Keep in mind, there are people who might have been close contacts or been exposed that you don't need to exclude because of their vaccination status says that no quarantine or exclusion is required. So it would be the entire, pay period that they're out up to the 10 days. And unfortunately, I didn't mention this, there is no limit to exclusion pay. So if somebody has to stay out longer, they're still asymptomatic, their symptoms have not resolved, then you have to continue to pay exclusion pay. And it's not also limited to, one exposure. If this continues to happen, there's no limit actually on the exposure, the exclusion pay that an employer could potentially be required to pay. And there's so many specific questions here. I will have to field some of these offline for sure.
Yeah, I see one about vaccination and tracking vaccination status. Yes, you should track vaccination status. You should track booster status. As Abe was just talking about the isolation and quarantine period, if you know who's been boosted, then you know how to apply the framework for isolation and quarantine. So really important that you track vaccination, track the boosters, continue to encourage people to get vaccinated and boosted because it makes managing the framework a lot easier. Somebody asked about the Santa Clara County guidelines and how they're more restrictive. For certain industries, especially in the medical space, employees have to have their booster by January 24th. And that just came out, which is a real challenge because people are just having a tough time actually scheduling the booster. So that, and then there's some other nuances about possibly not allowing the medical or religious exemption to play out. So there's a lot of changes that are happening. And as all these questions I can see here, we're continuing to try to stay ahead of it, but it's been a real challenge with the CDC, CDPH, and everybody else making changes pretty quickly. So let me move on because I want to talk about a few more things here. We do have the OSHA 300 requirement. We are in OSHA 300 season. This is a really important piece, especially for COVID cases. So remember that you have to post your OSHA 300 from February 1st to April 30th. You also have to submit your OSHA 300 log by March 2nd. So we've had all of these COVID cases. We need to record those if they're deemed work-related. And how do you know if they're work-related? Well, if you look at your workers' comp loss runs and you see your COVID cases on the loss runs, then I would go ahead and record those on your 300 log. You can mark those as anonymous, but you do need to include those. And I'll share one more second here. Let me move forward in these slides a little bit. So do I have to record my COVID-19 cases? Yes, but remember the case has to be a confirmed case of COVID-19 as defined by the CDC, and it has to be work-related. So those are the two key elements. And then you see the other elements with regards to just the general OSHA 300 recording requirements. Now, if an employee spends time in quarantine, is that considered days away from work? And no, that is not for recording purposes. So you will not mark the quarantine days in the lost day column. And let me show you what that looks like. Here's an example. We did a lot of OSHA 300 audits last year, and we found a lot of employers were putting quarantine days in the days away from work. You can see here, we've got the COVID-19 cases, they're marked as an illness, but then we mark those as 0 days away from work. So again, quarantine days do not count as lost days. If you have any questions or you need some help with auditing your OSHA 300 log, feel free to reach out to us. We can quickly take a look at it. A good way to audit your 300 is get your workers' compensation loss runs, see what injuries are on there and they're work related, and then just make sure that those line up to your 300. So COVID cases and then general medical and indemnity cases should be on there. Remember, first aid claims do not have to be reported on your 300 log. Excuse me. Okay, I know we've still got a lot of COVID questions. I hope we answered quite a few of them. I want to talk a little bit more about moving forward beyond COVID. So yes, COVID is front and center. We've got these surges happening. Short term, we've got a lot of compliance requirements, but I also don't want you to forget about the other safety requirements that you are responsible for within your organization. And just think, COVID is a door opener for OSHA. OSHA has bigger budgets. They've got more regulations. There's more personnel. I have seen more OSHA audits, more OSHA letters in the last 6 months than I've seen in a very long time. So they were sitting a little dormant while they were all self-quarantining, but now they're back in force and they've got a lot of requirements pushed on them by Fed Osha and this new administration. So what I want to talk about is how you can leverage technology in your 2022 risk management plan. As we talked about, documentation of your efforts is so important. And if you're still using paper and a lot of these processes, it is more of an administrative nightmare for you. There's a lot of really great technology that's available for you to help create more structure around your risk management plan, which will help you comply with a lot of these regulations and at least build your defense. And not to mention, as we talk a lot about building your defense against regulations and complying with all of these changes, it's also really important that you just maintain a safe and healthy work site. It's a really noble thing to keep your people safe. And people really appreciate that. And I know sometimes it's a burden for you, but I have never heard anybody say, oh, I love my 175% X mod. Nobody's ever proud of that. They're really proud when their mod's below 100% because it creates more opportunity for them bidding on projects, scheduling credits for discounts on your workers' compensation. So how do you do that? You have a really good system and a good cadence in implementing your programs. And COVID is just one of those. So here's some tools that I just want to briefly show you that are available out in the space. We have them. They're also available with different vendors. But digital inspection app. I've seen a lot of employers get away from conducting inspections, or they're conducting inspections and they're still filling out paper copies. That doesn't help you when you're trying to aggregate information and make more informed decisions on, hey, I've got risks in fall protection or housekeeping or machine guarding, and I'm seeing those commonalities across different sites, or I'm seeing that commonality continue to repeat itself time and time again each month. So we talked about 606, the egregious and the enterprise-wide exposures. If you start to recognize some commonalities and you have multiple job sites, then you can start to address those individually at each job site. You can work with your supervisors to shore those up. So digital inspection apps are really great for aggregating that data. It automates the reporting process so that it gets streamlined, which creates less administrative burden. And it also gives you data that you can use on an ongoing basis to make more informed decisions. One of the big things that I have seen employers, I don't want to say fail, but they've gotten away from doing it, is training. And training has become such a challenge because we've got people out from COVID, we're over capacity, we're understaffed, and something has to give. And so training has really given way because COVID has just kind of plowed through our organizations. But nonetheless, training documentation is really important, not only for COVID, but just your general safety exposures. And think about this, if OSHA comes in because of a disgruntled employee complaining about the lack of COVID exposures, they're not just looking at COVID, they're looking at everything else. So it's really important that you have a consistent training plan. And if you have a training schedule and you've completed trainings, then at least you can show that you've got documentation, that you are making a good faith effort. You're trying to comply with the regulations by updating your COVID prevention plan. You're providing training on exposures to keep employees safe. So you've got some record keeping that will, again, help you defend yourself against any type of OSHA audit. Task managers are great. I'll go through that a little bit. Cloud-based libraries are great. We'll go through that. And then our newest tool that we've been using pretty extensively is Power BI, Power Business Intelligence. And I'll show you how some of that works to create accountability. So from a digital inspection app, There's various ones out there, but here's just some screenshots of what that looks like. The great thing is, and I don't know if we have this client on the call today, but he was conducting about 5 inspections a month, paper copy, write up the email, download the photos, submit the report. There was never any aggregation of the information or the data. And since we implemented the safety inspection report, he's now able to do 20 to 25 inspections a month, and we can export that data and put it into some charts where we can actually look at that monthly at the safety committee and say, wow, we continue to see this spike over here, we should address that. So again, going back to that whole enterprise-wide exposure, now we've got an understanding of where the issues are, maybe per site, or even if we just have one job site, consistently which department might not be performing. That allows us to tackle those trends quickly and address the issues, and then we can move on to other safety requirements. Excuse me. From an online training standpoint, here's just a screenshot of what that looks like. Being able to administer trainings to your team via mobile, desktop, tablet. I know we have seen a lot of employers push back that my employees don't log in, they don't have an email address, and I think that we can easily overcome that. Gmail accounts are free. You can create Gmail accounts for your employees. You can train them how to use it. You know, once the link comes to the employee in their email, you can save their username and password, so that's just a few clicks to get them into completing the training. And I think that's a really important component of trying to reduce the number of clicks for those employees that might have a tough time navigating some of the technology. But I can almost guarantee you that every one of your employees has an email address, personal or work, because they have to log into schools, bank accounts. They can't function basically in this world without an email. So there is opportunities to improve that. It's just going to take a bit of an effort. As an example, we have a company that has 540 employees across 5 states, and it's a janitorial company. And we've had a real challenge to try to get all of them onboarded, but we continue to make that effort. And now we're up to 50% of that onboarding process, which allows us to start distributing those trainings across multiple sites. So again, doing inspections, doing trainings, we pull all that information in so we can see which departments are performing well, which ones aren't, where are our exposures, what kind of training should we provide based on the inspection data. So there's just a lot of really good administrative tools that are available to where we can get past the paper copies. And all of this is perfectly compliant. You know, having a certificate of completion per employee that's taken a training is worth its weight in gold when you're trying to fight or defend an audit. As an example, we had an employer have a fall protection issue. Roof collapsed, employee fell, the employee didn't tie off during the installation. And subsequently, what happened was the OSHA audit asked for training documentation on fall protection for that employee. And it took us a while to comb through all of that information. And then we found out that that employee was out on COVID the week that we did the fall protection training. But that took quite a bit of time to try to determine that, whereas in a administrated LMS system, we could quickly identify those employees that don't get the training, the day that they don't take it or the day it's due, and then we can follow up them to make sure that they get it. So kind of helps shore up some of those gaps that might be exposed within the whole training platform. Task Manager, we use a system called TaskRay. There's Trello, there's Asana, there's Basecamp. But essentially, once you develop your 2022 plan, back into what your monthly tasks are, trainings, inspections, safety committee meetings, and you can just build those into your task manager, and you just check them off as you move forward each month. You're gaining time by not conducting inspections via paper copy. You're gaining time by not conducting trainings and trying to record all the tailgate information and make sure you have all the signatures. So apply some of that time to task management. And here's just some different tools that you can use for that. Compliance library, I know we have a lot of Insight customers in here. We've got a whole slew of various policies, procedures. We'll share some new resources that we just updated from our Iipps to COVID prevention plans. But all of this is a cloud-based solution. And Dropbox and Box.com and Office 365, there's easy ways to share information now across multiple sites or multiple states if you're a multi-state employer. And cloud solutions are really a great tool to provide that information real time to all those employees, disseminated to their phones, their tablets, their desktops, so they have quick access to the policies and trainings that are required. Power BI. So if any of you are familiar with Power BI, and I know we have a couple clients that we've been building this out pretty extensively, this is an amazing new tool. It's a Microsoft application, Power Business Intelligence, and you can see some screenshots. This is real client data. So we're pulling in inspection data from an app. We're pulling in learning management system data from an app. We're pulling in workers' comp loss runs, mod worksheets, XMODs, which you can see down below to do an XMOD comparison. And we review this each month at the safety committee to really see how we're performing. And if you see in this next slide, this was a great way to start to build accountability. So we took the workers' comp loss runs, we took the XMOD worksheet, we assigned each injury to a supervisor, and we assigned the incurred cost of the claim to the supervisor. And then as we start to track that over time, you can see which supervisors are responsible for mod points, for incurred dollars, and ultimately premium dollars. And so as you start to build maybe an incentive program that's based on your safety results, you can see here Cedric, Armando, Jose, they're responsible for a significant number of points on the mod and a significant number of claim costs. So now we go back and look at their inspection results, we look at their training results. Are they not complying with the thresholds that we've created for our safety goals? And if not, let's work with them to figure out how we can improve this. So yeah, we've also, thank you, Joe, we've also added auto losses in here too. So Power BI has been just a great resource. It's all drill down analysis, so it's not just static Excel charts. You can really drill down and see different trends and results over different time periods, and it's super flexible in adding different data. We're actually pulling in information for one client from their rent manager app, pulling in data from other apps across their platform for what they use. So Power BI is a great hub for you to create some information to make more informed decisions. And given the time that we're in, risk management should be one of your priorities, from compliance to mitigating risks to mitigating costs. And this is a great way to go back to somebody's question at the very beginning. How do we comply with the ever-changing CDC, CDPH, Cal OSHA guidelines? If you have data like this, you can prove that you're actually making a very good faith effort in trying to mitigate costs and exposures. And also, this is great information for your insurance broker to take it to your underwriter at renewal and negotiate credits, because underwriters speak this language. So again, it's good for compliance, it's good for risk management for the organization. And just kind of one last little thing. This is just an initiative that we've been rolling out with a lot of different companies, just a safety recognition award. It's something really small. It's really easy to do. A lot of people are stepping up right now. You're understaffed, you're over capacity, and there's always individuals that are just stepping up and helping the organization, whether it's safety, whether it's operations, what have you. But just recognizing those employees and giving them a small little $20 to $50 gift card, it could be $20, could be a shirt, just anything that says, hey, thank you for stepping up. It goes so far, because you probably remember when we first started this whole webinar series, we talked about the fact that we're all in this storm together, but we're all in our own individual boat. And we don't know what everybody's boat is filled with. So sometimes these little awards go so far for people who are just struggling in their personal life. So I really encourage you, create a safety recognition award. There's Microsoft Word templates you can easily download, and then just start recognizing those folks. It will go a long way in really helping to build your culture, especially as you're forcing all these new regulations and compliance requirements on them. Okay, Abe, let's quickly go through this case study, because I think this helps kind of bring it all home. Do you want to talk quickly about the mod?
Yeah, thanks, Anthony. So yeah, just talking about the case study, I want to just run through why the XMOD is important. I know we hear a lot about the XMOD, and without going through the calculation, what is it? Why is it important? Well, it's really a safety credit score, but of course you want your mod to be as low as possible as opposed to an actual credit score. But your past losses affect your future XMOD, and that really opens up insurance opportunities. The better the mod, the more insurance carriers are willing to underwrite the risk. That's obviously going to translate also to insurance premiums. Having an active or a proactive safety program can help control your mod, and there's a clear financial incentive to do so and reduce workplace injuries. So just to drive it home a little bit, if we want to jump ahead and take a look at the next slide. This just gives an example of what an average XMOD is. Here, the example is 100,000. Bigger isn't always better. There's obviously a much wider range of the XMOD, but here we used a credit mod example of 75 and a debit mod of 125. And if you have a $100,000 average XMOD and then you reduce it to, let's say, 75, you're just multiplying the 100,000 by 0.75, you come up with 75,000. For a debit mod, it's 125,000 if you have 125 mod. Of course, this isn't exactly how premium is calculated. There's other credits and things involved, but this just gives you an example in a vacuum of how important an X mod can be. And just taking a look at a specific client's X mod history, they hired us in 2019. And I really wanted to show this because the X mod can be frustrating in a lot of ways because it's a lagging indicator. So even if you have a fantastic year, you're going to average it out with 2 other years worth of policies. And you can see even after we were hired here, it continued to creep up. It's kind of like trying to turn around the Titanic is a great example. And we did get a drop after the second year, but there was a lot that was going into that. It was driven by, starting them off with a return to work program, reducing their litigation, making sure we're reviewing reserves that might impact the X mod, just general claims management, making sure we're doing claims reviews and making sure that the carrier has proactive plans to resolve the claims. And this is just a snapshot from one of our reports. We break it down by policy period. You can see their various carriers as well as their decreasing exposure that they had, not only with frequency, but also severity. So for this specific client, Anthony, you want to talk about some of the KPIs and goals that we had? Except for not on mute.
That would probably help, right? So for those of you who are looking past COVID and just looking at your 2022 risk management plan, I know it's hard not to really focus on COVID, but a lot of you have been in business for a long time. We're going to get through this. So start to think long-term, how can we continue to improve our overall performance? So what you could do is take your workers' comp loss runs over the last 5 years, average that out, and then divide that by, or multiply it by 75%, which is how can we set a 25% reduction goal based on our prior history? You can do that from an injury frequency, injury severity standpoint. Lag time is a really important component that you need to track. You want to make sure employees are getting medical treatment immediately. And then you can see some of the lost day goals, having safety committee meetings, training goals and such. And so what that looks like is you kind of look at it from a dashboard standpoint. You set your annual goal, and then each month you're just looking, how are we performing? What is our frequency versus what our goals were? What is our severity? Are we reporting injuries on time? Have we completed our training? How are our inspection scores? So kind of bringing all of that, all those technology tools to a dashboard where you can review each month with your safety committee. And you can see the results here. We were able to achieve all of those goals by just staying focused, laser focused on what the initiatives were in order to help us achieve these goals. And here's the overall results. So from 2016 to 18, they were averaging 11 claims, 227,000 claim costs, 4.7 indemnity claims. The premium was going up, as you saw their mod going up, the premium was going up as well. The first year, we were able to get a 28% reduction in frequency, 75% reduction in severity, 15% reduction in indemnity. Premium continued to go up because remember, the mod's a lagging indicator. We haven't yet fully built enough momentum to really negotiate some discounts on the comp. And then as you look at this last year, we had a 45% reduction in frequency versus the average, an 89% reduction versus the severity, big reduction in indemnity claims. And then ultimately that allowed them to save $100,000 on their workers' comp premium. And we also projected another 30-point drop in their mod. So, excuse me, even though we'd had this increasing mod, the employer was saying, I don't know how we're going to turn this around. We really just got laser focused and implemented some technology tools. We started looking at data every month, making informed decisions, bringing the supervisors in, letting them know where we weren't performing well, and really building organizational alignment around those goals. And now they're in a much better position. They have more carriers that want to look at them. They're actually looking at trying to get into a captive in the next year or so. And now they've become, they have a lot of opportunities now because of what they've built, and it's becoming more sustainable day in and day out. So let's get close to wrapping this thing up here. I know we're right up on time. Here's some things that you can do for next steps. If you don't have a safety committee, I'm sure you do. You have to have one by now. Call it your COVID task force, call it your COVID safety committee, but make sure that you have a group of decision makers. You get together once a month and discuss some of the risks and challenges that your organization has. We've talked a lot about compliance. We've talked a lot about these regulations that are coming down the pike. So bring your team together and talk about your documentation efforts. Where are we falling short? Make sure you've updated your COVID prevention plan. For all of you Insight users, we've got all these new updates in the portal. Cassandra will talk about that in a second. Establish your goals. Yes, COVID is a goal. We need to navigate that and comply with the regulations. But beyond that, what are some of our other loss leaders, and how are we continuing to mitigate those while we're navigating parallel this pandemic issue? Develop a training plan for the year, complete monthly inspections. And again, there's a lot of technology that's available for you now. So, it's time to upgrade and make sure that you create some more efficiencies rather than being burdened by the paper tiger of inspections and trainings and such. So I just wanted to leave you with some final thoughts before I turn it back over to Cassandra. There's really three elements to your risk management plan. And one is the human element. It's the right thing to do. And I've just seen so many great questions that all of you are working really hard to try to comply with the regs, but also keep your people safe. And that goes back to that whole OSHA general duty clause of maintaining a safe and healthy work site. So thank you all for being here. I really applaud your efforts, all the things that you're doing. I know it's really challenging. Like Jennifer mentioned, day in and day out, we've been trying to field questions and help interpret these regs to give employers the most informed information. We have a compliance element. We have to do it. And we get penalized if we don't. But there's the final component that I don't think it's utilized enough, which is the marketing element. And having a good mod, having a good plan, that allows more carriers to really be interested in your overall business. It also allows your brokers to negotiate carrier credits or scheduled credits on your premium. Allows you to bid on projects, especially if you're in the construction trade. And one thing, it also helps you sell your business. So if you're looking at selling your business or acquiring another company, we just had one employer walk away from acquiring another company because their mod was 198 and they didn't want to absorb that organization because it would throw their current X mod off, which was really good. So there's a really important aspect from a marketing standpoint to have a good mod, to have a good program, be confident in it. So I'm going to leave you with that. I'm going to turn it over to Cassandra for some additional resources. Thank you, everybody. Thank you, Jennifer, for being here. You're always amazing. I really appreciate it.
Thank you for having me.
Hi, everyone. This is Cassandra. So just going to discuss some additional resources. Specifically, these resources are available to our Insight portal subscribers. So if you go into the compliance library section of your portal, you will see that you do now have an updated COVID-19 prevention plan for 2022 based on the updates made by Cal OSHA on the 14th of this month. You are able to put your company name in as well as your logo, and then it will auto-populate throughout the whole document. Please note, you still do need to look over the document, make sure that everything applies to you, and make sure that you are following all the things you're saying you're going to be doing. So you can outline those in a prevention plan, but then you do need to make sure that you are following through on all of the things that you are listing in that plan. Next, we do also have the computer-based trainings for you. So the ones available to our Insight subscribers are just for management. And then we do also have the learning management system for employees that Anthony went over. And this link here will take you to a page where you can actually request a meeting with us to discuss how to launch that for all of your employees. Next, we do have some updated safety tips. So these are the like PDF versions of the learning management videos. So we have COVID-19 general overview as well as worksite safety practices. So these are paper copies you can post, in the break room. You can use these for training. Just be sure to document all attendees and save that somewhere important. Next up, we have the updated Iipp, which does include the Employee Safety Handbook, the Safety and Health Policy, and the CSOP. We have multiple industries here. Again, you are able to enter your company name and it'll populate through, but do read through this. Make sure everything is applicable. If this is feeling like a lot, we are here to help. For our current portal, Insight portal subscribers, we can do a 30-minute safety consult. So please email safety@esminsight.com and we can schedule that 30-minute session to go over these documents and make sure that they are fully applicable to you, get those finalized so that you can continue to keep all of your employees safe.
Sandra, I'll jump in on this. This Employee Safety Handbook is a concept we created years ago, and it has been so important in some of the audits that we've completed. As you can see on the right side, we've got the Iipp, we've got the Code of Safe Practices. Your employees sign off, they receive a copy, and we have used this in defense many times to say we've trained our employees in lockout, tagout, machine guarding, fire prevention. It's just a synopsis of your overall safety program, but it complies with about 75 to 80% of your training requirements, your onboarding training requirements for OSHA. So I encourage you, go in, download it, email safety at ESM Insight. Cassandra, one of our team members, will reach out and then help you get that set up right away. It's a great tool to start 2022 with.
Definitely. And if you are not an Insight subscriber or haven't logged in a while, you can contact us. We can get you set up with Insight, or we can schedule a quick 15-minute training, show you how to log in, show you how to navigate the portal and find all of these resources. I will drop some links into the chat really quick before we end the webinar, so that you are able to contact us as well. All right. Well, thank you so much, everyone, for joining us. We are just about a little bit over, so I appreciate it. Oh, thank you, Anthony, for taking care of that. Anthony just put the email into the chat, so you can use that email to contact us with any questions that you have regarding Insight, the portal, any of the documents, getting that 30-minute consultation. We really look forward to hearing more from you. We will definitely, I've been saving the questions that everyone has, so we will be reaching out and answering those questions, either with some sort of FAQ, or if it's a very specific question, we'll go ahead and email you individually. Thank you so much for your time. We hope that this was informative and helped answer questions during this difficult resurgence and all the different changes. We will continue to stay abreast of all the changes happening, and we'll continue to have webinars and other support like this to make sure that you're keeping your employees safe. On that note, everyone, we hope to hear from you soon. Have a great rest of your day.